determine what a reasonable royalty is. We cannot say whether $1 or $5 is right or anything else. So please, in a way, that's something we cannot decide, and some judges even say we don't want to have this question in our court. What is now emerging, what the courts say we can do what we have learned, what we're doing all the time. We can apply legal criteria to what is going to happen here. So you bring your proposals, your negotiation process to us, and we'll look whether we see a discriminating behavior or a delaying behavior, and then we can decide, well, did you make a true friend offer? Is, in case of a willing licensee, did the other side make a true friend offer? And then we can decide under legal terms that we will grant an injunction or not. Now, is this the proper solution? And we have a saying among legal scholars in Germany when somebody comes to the judge and says, I want justice. The judge responds, you will not get justice here, you will get a decision. Meaning, now that's the continental coded law view of things. Of course, Americans would take a different view. But the upshot is, when you take things to court, you will get a decision, and you may not like it. Neither party may not like it. And especially if it comes to the point where the judges really need to review the whole negotiation process and to assess which party behaved properly, which party behaved improperly, always assuming basic willingness, then I feel that this will be a problem for the future, and this is on longer-term scale not manageable. Possibly to promote the process, but long-term not. But I'm afraid that's what the courts can do. The whole thing about the royalty base, I agree with Sheeta, that's a wild goose chase. And in this regard, it may be helpful that in terms of damages, the German courts, and in agreement, as I understand, with the US courts, say, okay, the reasonable royalty or a reasonable damage is the increase of value the technology brings to the device or to the method. That's very good for legal scholars. The problem is a practical problem. Actually, in a technology, in a mobile phone where a lot of things come together, and the interaction with the internet is just one part of the whole story. I think you cannot separate out one thing and say, this makes an increase of that and that much. Which brings me back to my initial statement. This is a matter of negotiation. It's a matter of market dynamics. It's not something that you should bring to the courts, because under analysis you will end up nowhere. Yet, if we think of the Internet of Things, I anticipate we need to go to the direction that was already mentioned before. We need to have some clarity. We need to have a simplified royalty process, because when you think of the Internet of Things, suddenly not only the telecommunication industry needs licenses, it's the car manufacturers, fridge manufacturers, all of them need a license. And then it gets difficult. You can compare licenses in the telecommunication industry, but you can compare a license in the telecommunication industry to a license in the fridge industry. The fridge industry says, well, we have a revenue rate of 5%, and hence any royalty can only be beyond 0.x, below 0.x%. Telecom may say, no, we are used to higher royalties. How do we reconcile this? And ultimately, yet you cannot make for every fridge manufacturer can negotiate for years, especially since the true technology is somewhere else. Just to add something to the debate, what Sheetal said is, of course, a nice thing about the capsule and the technology, but you can also say, well, the chip embodies the technology, that's the ingredient, and the mobile phone is a capsule. I would say, actually, what matches the compound in analogy is actually the technology that goes into it. And just to mention, there is of course some business interests behind this debate. For example, chip manufacturers would like to sell their chips more dearly. Everybody knows chip industry under some pressure. It would be nice for them that we can say, okay, we can increase the value of our chips because there isn't that technology added in it. And of course, I'm not only talking about telecommunication, but also other technology that goes into a chip. So that's another aspect to the story. Ultimately, it shouldn't matter whether you have the chip, handset, car, airplane, whatever. Ultimately, it's the value of the technology that you pay for.
Yeah. Thank you, Stefan. There's this concept of the smallest saleable patent-protected unit that has permeated the case law in the United States. There's a long body of high court decisions that go back 10 plus years now, where what's critical to this, of course the rate and the base go together. You can have a high base and a low rate or vice versa. And when you're doing licensing across many, many markets, and you go to court, you have to show some consistency in your approach. So this is why the process becomes important. If you can't show consistency to the court, you can't manage your damage award effectively. You can't say that we have this, even though every deal may be a little bit different, you can't say that our approach has been common, and that's what you want to be able to say to get the damage award if you're an innovator and a patent owner in an American court. What the significant trend in the United States, if I were to identify a trend in terms of this royalty base and royalty rate question, it's the process by which the court looks at the issue. And do you start from a top-down approach, a high rate look, and then work it back down, or do you start at a base rate, a small saleable unit type rate, and work your way up? Our courts in the last 10 years have moved in a direction of turning away from looking top down, and now they're looking more bottom up, which is in court decisions lowering the value of the damage awards. That's not necessarily a bad thing. I mean, these go back to some Microsoft cases when the catchphrase that was used in the litigations was the entire market value rule. And it was a rule that said, you can look at the entire computer as the royalty base in calculating a damage award, and then figure out a rate that goes with that entire computer for the API that was really the point of innovation. We've since eliminated that as the starting point. Now you start from the smallest saleable unit, and you have to show that the value of that smallest saleable unit, the chip that Sheetal referred to, and as Stefan was saying, you have to say that that smallest saleable unit drives the sales in a significant economic way in the marketplace in order to increase the the base royalty above the smallest saleable unit into a higher realm. So more and more it's becoming an art of argument, is explaining why, as Sheetal says, that little chip inserted in there really drives the sales of those 4G phones and not all of the other innovative and patented technology that's in that phone. It's a significant change in the policy in the United States, not the policy, but the court decisions, this process of determining damages. Because, and I'll come to it with our next point, which is where I'd like to turn now, royalty base and royalty rate all are nice things to talk about, and the balance is very important, but at the end of the day, if you don't strike deals, it doesn't mean anything. And you've got to get willing innovators and willing implementers to come to the table, as Sheetal was saying. And how do you do that? I think one thing that's missing from the American landscape right now is the injunction. We have them nominally, but we don't have them practically. And I think we've worked the damage awards down in the United States. They're now reasonable damages for the scale of the market that you get with your innovation, your patent-protected innovation. But what you can't get is the implementers to always show up at the table. And you can have say that there's a holdout problem, but it's, in my opinion, holdout is not significant. What's more significant is hold up. What's more important is the hold-out issue, the reverse hold-up, where the implementers, as Sheetal was saying, aren't coming to the table. So I'd like to turn to that topic if we can now. Beyond the royalty base, royalty rate, let's talk about the injunctions. We talked a little bit about that as a significant trend at the onset of our panel. That's something that is in all of our markets here, Asia, India, US, Europe. I'll start off again with my colleague Sanjeev, and I'll let him do what happens in American political debates. He can address the previous question as Donald Trump and others, Hillary Clinton did in every one of their debates, whatever question he wants, but then turn to the injunction issue.
Yes.
And let's see, we can expand the discussion of our earlier discussion on these initial injunctions and whether they're good or bad for the system.
Thank you, Patrick. And essentially, all boils down to the injunction issue, essentially. And just picking up where the Deepak and Sital and you left, and the injunction. The injunction issue is valid because of allegation of the infringement. Now, when we talk about the essential patents and the injunction in relation thereto, then there are peculiar facts which one need to keep in mind. The peculiarity is this, that there are three important factors. A patentee comes to a court alleging infringement of essential patents by merely saying this, that this implementer is selling its handsets or is in this particular area, say 4G, and they are 4G standard compliant. Simply by virtue of being 4G standard compliant, they are essentially infringing my patent. This is the essential assertion in the case, or a plaint or a complaint to the court, that since they are compliant to a particular standard, their network or their mobile handset is violating our patent. Now, this brings me to that particular, from where it is established that because a particular implementer is following a particular standard, he must be infringing the patent. Let us see the background. The innovator, to begin with, has only suggested that my patents can potentially read on the standard. He is not sure. While putting his patents into the pool of with the SSOs to the standard setting organization, by merely saying that my patent could be a potential essential patent, he still is not sure. A standard setting organization has no mechanism to ascertain that all the features of this patent are reading to the standards. There is no certificate by a standard setting organization. In that context, the court has to accept the fact that this patent is an essential patent to a particular standard, and then only the court has to grant either interim injunction or the final injunction or the ex parte injunction. In that context, the royalty and that becomes relevant, and the injunction also becomes relevant. Certainly once it is established that all the features of the patents reads upon the standards, implementer is following the standards, the implementer has to be injuncted if they are not agreeable for a reasonable royalty. And considering the facts that while determining the royalty, courts so far in the court's decisions, we have seen lower amount of royalty. What was the rate for bargain between the parties? That the rate offered by the innovator company and rate which was suggested by the implementer company. We have seen the award by the courts on the lower side. And then keeping in the mind that each and every court virtually, either in India or US or even UK, they are looking at the 15 factors laid down in the Georgia Pacific case. Indian courts have followed the Georgia Pacific, and thereafter the cases based upon that, either Verentex or the Cisco, the Indian courts have looked into. Considering from the Indian scenario, Indian courts have looked on the 15 factors of Georgia Pacific right now at the prima facie stage. So in fact, even today for the innovators company, there are guidelines in the form of Georgia Pacific, in the form of Verentex, in the form of various pronouncement in the either Microsoft or the Cisco or the Interdigital, where the court has either adopted a bottom-top approach or the top-bottom approach. Now it is for the innovator to assert that this particular patent is essential, and this essentiality would lead to value addition to the entire handset, or value addition to a particular feature of the handset, and accordingly, and that's why, to my mind, to begin with, innovator company has to come up to, they have to show their bona fide to the market for the various kind of